Picture this. You're injured by a defective product or caught up in a massive class action lawsuit. You know you've got a strong case, but you can't afford the legal fight. Enter the litigation financier, a business that essentially says, we'll fund your case. If you win, we take a cut. If you lose, you owe us nothing. That's the business of litigation finance, sometimes called legal funding. Think of it like venture capital, but instead of investing in startups, they're investing in lawsuits. And like venture capital, the information, the data models, risk pricing formulas, and insider knowledge can be worth tens, even hundreds of millions of dollars. The idea isn't new. Versions of third-party funding date back centuries, but the modern industry took off in the 1990s in the UK and Australia, where reforms opened the door to outside investment in legal claims. In the US, it gained traction in the 2000s, first with small personal injury cases and then expanding into giant mass torts, patent disputes, and commercial litigation. Today, it's a multi-billion-dollar industry and competition is fierce. But what happens when the secrets of this industry are at stake? Enter Archetype Capital Partners and their staggering $100 million lawsuit against former co-founder Andrew Schneider. Archetype claims Schneider walked away with confidential data, everything from proprietary underwriting models to client acquisition strategies. They allege he used this information with the help of Bullock Legal to start a competing venture. So the question is, was their secret sauce stolen? The law here centers on trade secrets. Under the Defend Trade Secrets Act at the federal level and parallel state laws, a company has to prove three things. First, the information is truly secret and valuable. Second, they took reasonable steps to keep it secret, like through NDAs or restricted access. And third, the defendants misappropriated it, meaning they used it without permission. If all of that's proven, damages can include lost profits, unjust enrichment, and even punitive awards. Archetype says they did everything right. NDAs were signed, security protocols in place. Yet shortly after Schneider left in 2025, competitors popped up using the same methods Archetype had pioneered. They're claiming over $100 million in damages from lost leads and market opportunities. The defense, when it comes, will likely argue that the methods weren't really secret, or that the rivals independently developed their own models. That's a classic tension in trade secret cases. Where does general know-how end and protected secret begin? And let's not forget the ethical questions. If a law firm like Bullock Legal helped exploit confidential data, did they cross ethical lines? Lawyers are bound by professional rules against using client confidences. This dispute could impact not just finances, but reputations and careers. But here's the bigger picture. Litigation finance thrives on innovation. The formulas for evaluating cases and predicting settlements are what make or break these firms. If insiders can walk away with these formulas unchecked, could it chill investment in the industry? Might we see stricter contracts and increased surveillance of employees? In short, this isn't just one company suing a co-founder. It's a story about the growing pains of a billion-dollar industry at the crossroads of law and finance. How fragile is competitive advantage when secrets don't stay secret? So what do you think? Is litigation finance the future of legal battles or a ticking time bomb of ethical dilemmas? Let me know in the comments below. And don't forget to subscribe for more insights into the fascinating world of law and finance.